Our last speaker today is Patricia Ayodeji. She's Bachelor of Law with honors. Congratulations, Patricia. And she is member of the Colegio de Abogados de Barcelona and also member of the Law Society of London. So he practiced both in United Kingdom and in Spain. She's founder of E-PDP. She's a specialist in personal data and in intellectual property law. Patricia is based in Barcelona, and she's multilingual. She speaks Catalan, Spanish, and I don't know how many languages more.
No. Three.
But thank you. It's always an honor to Patricia, and Patricia will help us with the European point of view regarding data protection.
Thank you. One moment. Thank you, Agustin. Primer de tot, bona tarda a tothom, no? Una mica de català, no? Sempre està bé. Right, I'm going to do my presentation in English, but as Agustin said, if you have any questions, feel free to ask questions in Spanish or in Catalan, okay? I'm fluent in both, and I'll help with any translation. I'm sure Agustin will as well. So don't be there thinking, oh, no, I want to ask a question, but I don't want to ask it in English. It's possible to ask in Catalan or Spanish. Okay, so firstly, I want to say thank you, especially to Agustin of Argalich Networks and George of Macom for inviting me to speak here today. I think it's a really exciting topic. I think the timing is absolutely perfect. I know that a lot of my clients based not only here in Spain, but also in the UK, are asking this question at this moment in time. They're confused about what they can do and what they can't do, and hopefully today we will help clarify some of those doubts that you have. I am an information technology lawyer, but like George's, I'm not very good at technology, so we'll see if this is okay or not. I think the important thing to stress is, at the moment, is whether we use American cloud providers or cloud providers from Europe, there are responsibilities which must be met, okay? It's not possible to exclude our responsibility for data protection, our responsibility for data confidentiality, our responsibility for data security, data integrity, or business continuity. They are all 5 factors that we need to bear in mind when we choose our cloud provider. Any contractual clause trying to exclude these responsibilities will be deemed invalid. I will emphasize today privacy, but all 5 factors need to be taken into account. Martha's already mentioned this guy, no? Edward Snowden. Edward Snowden, certainly, there's certainly a before and an after Edward Snowden. Everybody's opinions change on whether he's a hero or a traitor. I would actually like to know, now that we have some Americans in the room, is he a hero or a traitor?
My guess is that Rick and I will disagree on this one, but I am the child of 2 newspaper reporters. So I would say he is a hero.
I'm going to try to say it depends only 3 times during this entire presentation, and I'm going to use one of those now. I spent 22 years in the United States Air Force before I became a consultant. There are some secrets that need to be kept, absolutely. There's a line, and sometimes we don't know where that line is. Sometimes when you look at that line, it's very fuzzy. What Edward Snowden did was, instead of drawing the line, he threw out the entire sheet of paper. So I don't think he's a hero. I think he identified an issue to be addressed, and I think it needs to be addressed.
So shockingly, although we don't agree on the final outcome, we agree on the content, because I agree with your assessment as well. See, we can agree.
Thank you. I've always wanted to ask an American that. Okay. I want to emphasize that the Americans are not on a par with us in terms of privacy. They're simply not on a par with us. Okay, their data is governed by a patchwork of state and federal laws. We in Europe have a more harmonized regime. I want to emphasize two American laws, which I believe are both at federal level: the Privacy Act 1974 and the recent Judicial Redress Act of 2015. The Privacy Act guarantees three primary rights. I'm just going to read the last one, and they must be abided by the federal agencies. The right of individuals to be protected against unwarranted invasion of their privacy. Unwarranted invasion of their privacy. This act only applies to Americans. Okay, they're the only ones who have this right, which the federal agencies must abide by, or non-Americans who reside there permanently. So basically, in this room, it applies to you two, no? Nobody else, no? I'm Fran. Oh, I'm Fran. Hi, Fran.
Okay.
Right, three people in the room. Okay, there's also the recent Judicial Redress Act, which gives U.S. allied countries the right to sue federal agencies for mishandling their personal data. But this act only, as I said, applies to U.S. allies. The U.S. allies, the closest ones at the moment, I think they don't include France. I don't think. We have quite a flaky relationship with America, no? The relationship with America, is it good or bad or?
French? Yes, it's good.
It's good, it's good? Okay.
I don't like it to be good, but it is officially good.
Today. Spain is not a US ally that I'm aware of. And the main allies are the UK, but I live here, so I don't think I'm protected either. New Zealand, Australia, Canada, those are the allies. So unless you come from those countries, you also, under this new act, don't have the right to sue federal agencies that mishandle your personal information. So we're in quite a weak position.
Allies, excuse me, Patricia, allies is not the NATO, or it's
It's not NATO, bigger than
it's
the NATO
not NATO,
alliance?
it's something else?
Not
No.
who's-
When you said allied,
Yeah, NATO is much bigger than just those countries. But
No, it's bigger, but I'm talking about the close allied countries. I haven't actually read word for word the act, but I know that it talks about its allied countries, and we certainly know that some of them exclude us. Spain, we know, is not an allied country. Okay? So why is the European approach such a headache for the Americans? It's a headache for the main 5 points that I've pointed out that we need to make our transfers to the US legal. Privacy, security, confidentiality, data integrity, and business continuity. All 5 factors are important. The starting point is a Charter of Fundamental Rights of the European Union. Article 8, everyone has the right to the protection of personal information, personal data concerning him or her. And just repeat that. Everyone has the right to the protection of personal data concerning him or her. And this is where Snowden comes in, no? Because there's respecting the European Fundamental Charter, I don't think was the case. No? So in Europe, we have, most of you already know this, but I just want to recap. And the data protection legislation, we have the directive at the moment, which was transposed into the LOPD in Spain. It's in the process of reform. We expect it to be approved soon. The new regulation, it's a regulation as opposed to a directive which we have now, will come in force in 2018. It's, from a privacy lawyer point of view, it's a very, very exciting regulation. Perhaps not perfect, but it certainly deals with a lot of the issues that have come with the changes in technology. There are just 2 aspects I want to talk about today. The first one is that it will be one single law. So it will be the same in Spain, the same in the UK, the same in France, the same in Italy, the same in Germany. At the moment, we have a law, which is a directive, which is interpreted slightly differently in each member state. But it will be one single law, which means that from 2018, which is when we expect it to come into force, Ireland will no longer be a soft option for US companies. It will no longer be a soft option. It will be applied the same in all countries. The other point I wanted to make was about territory. We've had jurisprudence over the last couple of years as to whether European law is applicable to Google, Facebook, etc., yes or no. Jurisprudence has established that yes, it is applicable, but the new regulation clearly mentions it and clearly says that the regulation will apply to all non-EU companies, whether they have offices or headquarters in the EU or not, but who offer goods or services to EU citizens. That is the only requisite. Goods or services to EU citizens, whether they're paid for or whether they're free. So that's quite a dramatic change from the current directive that we have. Some data protection questions we should ask ourselves when we're deciding on whether to use an American cloud provider or European is, do they share the data with third-party subcontractors? It's important that we know who they are. It's important we know the type of services which are outsourced, and it's also important to know where the servers are based because, as Martha says, it matters. Bearing in mind that responsibility in the case of mishandling, responsibility in terms of breach of personal data will lie with us. Although in a contract with your provider, you can include an indemnity clause, but the client will virtually go firstly against you. No? So it's important to have certain guarantees. 2015 was quite a good year for privacy from the European point of view. Not such a good year for Google, Facebook, Yahoo, etc. And I hope there's no representatives in the room today, but not such a good year for them, no? The turning point, as Martha's already said, in international transfers was the strike down of safe harbour. The judgment, which was a Schrems judgment, invalidated the legal basis for safe harbour. So if your company today is still relying on safe harbor for your cloud services or for transferring your data to the US, it is in an illegal position.
Let me just interrupt you for a second and just say that you may know this, you may not, but if you have a current cloud provider, the first question to ask is where is the data? I think it's a question that you need to ask. I don't think that it's all that people always know. End users always know.
Oh, thank you, Martha. Okay, so it may face enforcement proceedings, depending on the data protection authority in question. The Spanish Data Protection Authority was quite clear. They sent letters to companies who had ficheros, files in the registry with transfers to the US, advising them that they needed to modify those transfers. And also they published on their website an announcement giving us until the end of last month to modify our files or to notify our transfers to the US. So if you haven't done that, the Spanish Data Protection Authority may choose to temporarily suspend your transfers to the US. So it's very important. The American response to Schrems was slightly different, no, Martha?
That's correct.
Yeah, we talked about fundamental rights were breached, that there wasn't an adequate level of guarantees, but the American response from the Secretary of Commerce was that they were deeply disappointed.
Well, I'm not taking her side here, but they were disappointed because it creates problems for U.S.-based businesses. I don't think that obviously I don't know what was going through her mind, but I think the fact is the Schrems decision creates additional and although perhaps they shouldn't have been, unexpected challenges for those businesses that are providing cloud services in the U.S.
Right. I just want to continue reading, and maybe you can comment on this as well, word for word, what she actually said. Amongst other things, the decision does not credit the benefits to privacy and growth that have been afforded by this framework over the last 15 years. Benefits to privacy for who? For the Americans or for the Europeans?
Well, I think what she's saying is simply, what's a good way to say this? I think what she's saying is that this creates unanticipated challenges, and that we've done a good job of policing ourselves. When has that ever been effective? I don't know that it has. Certainly there are some occasions, but what this response is, oh, we've done a fine job as it is, and clearly it hasn't. But again, you have to remember the earlier slide, which recognizes the differences and the distinctions between how Americans view privacy and how Europeans view privacy. I think that's inherent in this kind of comment. It's that we're not coming at the question from the same place.
No, exactly. And we'll see if we reach that point. I'm going to mention that a little bit later. We reach that point and come to that. So anyway, the crux point is that everybody wants to know, no? We want to know how we can use American cloud services without running afoul of EU data protection law. Martha's already mentioned there are alternative data transfer compliant mechanisms. Okay, I haven't mentioned consent here, but we need to remember consent. Possibility, data localization, the actual whereabouts of the data. Where is the server? Okay? A simple and effective means of avoiding any kind of doubt is to migrate. Okay, from, for example, MailChimp, which is Georgia-based, and whose privacy policy clearly states that they disclose personal data to comply with court orders and subpoenas, and many contracts with the American contracts also have that clause, to moving it simply to the Madrid-based Mail Relay. The problem is over, no? They have their data centers in the EU, no problem. Some of you may have received emails or letters from Mail Relay saying that, you know, Safe Harbor is dead, you have to migrate now, you're in a legal position. Safe Harbor is dead, that's true. Migrating is one option, okay? Obviously for Mail Relay, it's a really good business opportunity. There are also the EU standard contractual clauses, which Martha's already mentioned. I'm not going to go into detail. Only I say that for my Spanish clients, I ensure that they have the contract signed by both parties, not only in English, but in Spanish. So both parties are clear about what their obligations are. Both parties are clear about what the other party expects from them. We also have binding corporate rules, which offer great flexibility and are a valid solution. All of these solutions were available before the Schrems judgment, and they continue to be available, and they continue to be legally effective. I will say that the EU model contractual clauses, there is talk about reviewing them in bearing in mind the Schrems agreement, but at the moment we can use the standard clauses that we have. So just when we thought there was no solution, suddenly and recently they announced a successor to Safe Harbor, no? The so-called
And after our presentations were done.
Presentations were done. EU-US Privacy Shield. Fantastic name, no? Privacy Shield, I quite like the name. It's supposed to be a new living framework for transatlantic data flows. It's supposed to be constantly monitored and with an annual review. And it says that EU citizens will benefit from legal redress for privacy violations. So the protection that we don't have under the Privacy Act 1974 or the Judicial Act 2015, perhaps we will have it under the Privacy Shield. We don't at the moment in time have all the lettering. We don't know exactly what it says. We probably won't know until the end of March, April this year. But it looks promising. The only problem is that it has to pass the scrutiny of the Working Party 29, which is the body of representatives of the different data protection authorities, and it has to pass the scrutiny, which won't be so easy, of the European Court of Justice, which is the ultimate responsibility, the ultimate voice on whether it is robust enough, whether it is stronger, and whether it provides us with the guarantees which Safe Harbour didn't provide. So at the end of the day, the deal is not done. The situation is exactly the same as it was after the Schrems judgment, and we have to wait and see. Do you agree with that, Martha?
I agree.
Right, we agree on some things. Right. Briefly, just want to mention again, it's not all about privacy, okay? We have different aspects which also have to be met under the directive, which will soon be the regulation. Security, bear in mind Snowden, employees are the weakest link. A good sign of a good provider are these two ISO standards. They're not obligatory, but they do show that the cloud provider has the kind of guarantees which we would expect from them as Europeans. As we said, these presentations were available for anybody who wants, so you can just take a note of which standards I've talked about. I want to emphasize that data breaches happen, and they happen every day. Okay, this is a really good website. I recommend that you look at it. It's called informationisbeautiful.net. If you click on the bubbles, it shows the different types of breaches and the amounts, the number of people, the different sectors. We see big names here: JP Morgan, eBay, Uber, Ashley Madison, which I'm sure everyone's heard about. That was quite a sensitive breach. Have a look at this. They happen every day. Why am I mentioning that breaches happen every day? Because the new regulation in terms of sanctions will be stricter than the current system that we have. Okay, they're talking about up to 4% of the turnover of a business. So we're talking a lot of money. So it's important to have this under control. I'm finishing. Confidentiality is something else that we need to take in terms. Think of encryption, access codes, who has access to them, passwords, recovery, etc. Data integrity. If we want to change our cloud provider, how long will critical data be inaccessible? Important in terms of the directive. Continuity. I'm finishing, Agustin. Continuity. Okay. Portability is a new right which is guaranteed under the new data protection regulation, which is specifically for cloud, okay? The ability to get information in a format which is compatible with other systems. The ability to get information from the cloud, the American cloud provider, to shift it to a European one or to simply another American one. It's a guarantee under the new regulation. So yes, we can make our transfers, we can use American cloud providers, but we must remember Safe Harbor is not an option. We must remember that the Privacy Shield at the moment is not an option, and it needs to be one of the data transfer compliant mechanisms which I've already mentioned. So thank you very much. Muchas gracias.